Hey, it's James, Father's Rights and Resources, hashtag HowiGotCustody. I was inspired to do another post today. This is probably the most videos I've done in one day. But there was a guy who commented how he was ordered to get a mental health evaluation. I believe I talked about this before, but I thought I'd jump on it again. What's usually pretty hypocritical about that is I don't think there's any attorneys arguing this point. But if you know the rules of evidence, nobody could testify to anything unless they have personal knowledge of something, or if they have expert knowledge. And judges can't testify and lawyers can't testify. What usually happens in family court that I see all the time is somebody will say, oh, he's crazy, he's got a mental health problem, he's got an anger problem or whatever. And it happens to some mothers too, and mothers get screwed on this sometimes. But they'll go in and just allege they have mental health problems. Or they'll allege that they did this or did that. So in order to see your kids, you got to get a mental health evaluation and jump through their hoops and recommendations. And a lot of times the other side will find an evaluator that's in bed with the lawyer or one of their buddies, and they have handshake agreements. If anybody ever tries, and the mother in my case tried to request a mental health evaluation twice, and the court didn't buy it. I made them look stupid, and I wasn't ordered to have to take one. One of my arguments is, though, that the number one parenting evaluator in the greater Seattle-Tacoma area for decades, at least 2 decades, maybe 3, was Stuart Greenberg, S-T-U-A-R-T, Greenberg, B-E-R-G. It was like an iceberg. So Stuart Greenberg was the number one parenting evaluator. He was a psychologist. He was on the University of Washington's Board of Psychology. And if he wrote a report saying the father should have custody or the mother should have custody, the courts pretty much adopted it. Just because the courts don't want to do work. They want to appoint a guardian ad litem or an evaluator, have them do all the dirty work and be the eyes of the court out in the field supposedly, and do all the court's work and come back and report. And then they just believe their word as if they would never lie or ever get anything wrong. And attorneys are so stupid, they won't put them on the stand and cross-examine them or whatever. So Stuart Greenberg was arrested for voyeurism because this coworker or somebody working down the hallway from his office was using his bathroom and found a camera in the bathroom. She called the police. The police found a bunch of footage of a bunch of women and coworkers of his that were undressing in there using the bathroom that he had videotaped. And the thing is, children use that, like if a mom came to get a mental health evaluation, their daughter might go in that bathroom or whatever. So he was arrested. All you got to do is type in Stuart Greenberg, Seattle, and you'll find an article on him. He was arrested. He got out on bail, then he killed himself, and he left a note saying, I ruined so many lives. So for years, this guy was a sexually deviant pervert using his position as a well-known and well-renowned psychologist and parenting evaluator to get off on women. And I know a woman who was interviewed by him, and he used to ask her a bunch of sexual questions, and she didn't know what that had to do with her case, but he had her, so to speak, by the balls, so she couldn't really question or stand up to him, so she just had to answer his invasive, irrelevant questions. So it turns out, Stuart Greenberg was married to Judge Joan Dubuque, who's dead now. She was a judge in Seattle. As far as I've heard, he used to write reports, and when she was a family law commissioner, she would rule on those reports, and they must have had a dating relationship or whatever. And my judge, Judge James Rogers, he was buddies with Stuart Greenberg and business partners, and I bring that up all the time, that he loves sexually deviant perverts, including the opposing attorney in my case and Stuart Greenberg, and he'll never deny it. He just kind of keeps it moving along. And so that's why when I protest outside my judge's house, I have a sign that says that he's BFFs. And I have a video on YouTube that my judge is best friends or BFFs with Stuart Greenberg, a sexually deviant pervert. And I'll be doing that and exposing that guy for the rest of his life if I have the opportunity to. Let everybody in his neighborhood know there's a sexually deviant pervert, lover, racist, whatever. And I don't throw the term racist out lightly like a lot of people do for political reasons and stuff. But in any case, I point that out that the number one experts out there are sexually deviant perverts and mentally ill people. 75% of psychologists have a mental health disorder, according to some studies. So that being said, here's the number one crux of my argument against getting a mental health evaluation. Why am I ordered to not see my kid or to have restricted visitation pending a mental health evaluation? It's supposed to be you prove something's wrong with me and then take a right away. What you're doing is you're taking a right away until I can unprove this thing. First of all, that's backwards. That's anti-due process and backwards. The family courts don't care because that's how they operate. You don't throw somebody in jail. Like, they hold them in jail for a while because we got problems with our criminal justice system, but you don't give somebody a sentence of life imprisonment or the electric chair because you think they might have done it, and until he can prove that he didn't do it, he'll be in jail on death row or whatever. Just the other way around. You got to prove that he did it or you let them go. So if they think you have a mental health issue and they want to restrict your visitation because of a mental health issue, first of all kinds of stats out there say 80% of people in the country have a mental health issue. Anxiety, depression, people have prescription drugs are through the roof as far as, obtaining prescriptions and use of drugs and abuse of them. So you could say, well, 80% of judges got a mental health disorder, so let's start taking kids away from judges. That's what I would tell a judge in court. That's asinine. In Washington, the law, RCW 2609-191-3, I forgot what subsection is, but it says an emotional impairment that interferes with parenting functions. To me, you got to prove all those elements before you take the child away from me. You have to prove that I have an emotional impairment that interferes with performance of parenting functions and that it's a permanent emotional impairment. You can't do that until you get a mental health evaluation. So here's the thing. It's a catch-22. You have to prove that I have a mental health problem before you take my kid away. You're saying I need to go get a mental health evaluation because you're concerned I have a problem. Where do you get that from? Because you're not the judge, you're not a psychologist. The mom's attorney's not a psychologist. The mom's not a psychologist. You can't evaluate me. What you should do is give me equality or 50-50 in order that I get a mental health evaluation. If nothing turns up, then the mother pays for it. Or make her pay for it because she requested it, because there's no proof that I have it, because she trusted me with the kid. If the number one argument most of the time in court against domestic violence or I'm a bad parent or whatever is how the mother allowed me to be around the kid overnight for weeks or months or years. That's the number one argument. Nobody ever uses that for some reason. It's insane and crazy. If she's telling the truth, then she's a child abuser because she let me have the child all this time up until yesterday. Or you can't believe anything she's saying because she has a vindictive personal vendetta against me because she doesn't believe her own allegations because she left the child with me and she just offered it yesterday or whatever. But also, ER 702 says you can't testify to expert testimony unless you're an expert witness. ER 605, I think it is, or 609 says a judge can't testify. So what a judge will get up there and say is, oh, you're showing signs indicative of mental disorder. Objection, you're testifying. Objection, you're acting like a psychologist. You haven't evaluated me, so you don't have personal knowledge of my mental health thing. You haven't used any tests in the DSMV. You haven't sat down and done any kind of questioning or testing of me. And everything you're believing on the mother's side, you've never seen, so you don't have personal knowledge. You're not an expert witness, so you can't make a finding that I even have concerns of a mental health disorder, because then you'd be testifying or you'd be acting like a psychologist, and you can't do that. And the mother's attorney is up here saying, well, he looks like the same type of profile as a guy in another case that got a mental health evaluation. They found out he was borderline personality disorder. He's testifying. Attorneys can't do that under the rules of professional conduct. And that case has nothing, and then that's hearsay or, he's talking about a different case that's not relevant to this case. There's all kinds of objections you can make under the rules of evidence that should be made immediately. But before you even go to trial or to a hearing, you should be doing it. If you got an attorney, the only thing that attorney's worth is doing a deposition on somebody. You should never go to court, I don't think, without doing a deposition and grilling the crap out of somebody and getting answers to all their declarations and all the witnesses against you and knowing the answers ahead of time. So I'd be objecting to all that stuff. They can't say they have concerns about a mental health evaluation if they're not an expert to determine whether there's a concern of that.